In a medical malpractice case, when I am questioning a doctor in a pretrial process known as a deposition, has it ever happened where the doctor turns to me and says, "Mr. Oginski, you're totally right. I give up. I throw my hands up. You're absolutely right. I screwed up. And now your client should receive compensation for my wrongdoing." Has that ever happened? You want to know the answer? Come join me for a walk along the beach as I share with you an answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is, in my career, I've been doing this now more than 34 years, I have never, ever seen that happen when I'm questioning a doctor at their deposition. However, I had a case recently where it was a significant case. My client had been questioned at this pretrial process known as a deposition. It's a question and answer session that takes place before ever getting to trial. Lawyers also call it an examination before trial. The defense lawyer had an opportunity to question my client for hours and hours. It lasted the entire day. They asked her every single question under the sun, every possible question they could ask, because they wanted to learn from her in her own words exactly what had happened, and they wanted to learn what problems and damages and injuries she had as a result of what she was claiming the doctor did or did not do. So they spent a considerable amount of time questioning her. Now, after my client is done being questioned, now we begin to schedule the doctor's depositions, and there were a few doctors involved. Now, after my client's deposition was completed, the next step in the litigation process is to go ahead and start scheduling the various doctors who were involved in this case for their deposition. And that involves a number of things, including getting the availability of the attorneys, finding out the availability of the doctors, to make sure every attorney who's involved in the case has availability on a particular day. And then once we have a confirmed date, now we go ahead and when that date comes, we have to order a court stenographer so that there will be somebody on the call to go ahead and record all of the questions I have asked together with the doctor's answers. Now, what happened in this particular case? In this particular case, the defense, even though we had scheduled deposition dates, they kept adjourning, they kept pushing off this doctor's date. They did not want to go forward, and they wouldn't tell me why. They kept telling me the doctor was busy or the doctor was called into an emergency, and they came up with one excuse after another. This went on for a total of 6 months. Now, that's highly irregular. Why is that irregular? It's because the court has a schedule, and they expect us to stick to a schedule, a discovery schedule, about when things are supposed to proceed. We were supposed to have done the doctor's deposition within a few weeks after my client was questioned. But in this particular case, we couldn't get a definite date where the doctor was coming in for over 6 months. Now, there are a number of things we can do in that instance. We can make a big stink and call the attorney who represents the doctor and now have a discussion with him or her and explain that this is simply unacceptable. The alternative is we can now try and get the judge who's responsible for overseeing this case. We can get the judge involved and let them know that we are having a discovery issue and that the defense refuses to produce their client for a court-ordered deposition. Sometimes the judge will get us on a call, and now we'll have a discussion and the defense will have to answer and explain why they have not produced their doctor in a timely fashion. Other times, the court doesn't want to hear this nonsense because to them, this is nonsense. You see, in New York, the attorneys are required, we are required, and there is a court rule that says lawyers are required to work together to schedule discovery and to try and resolve discovery disputes without involving the court first. If we don't do that and we go rushing to the court first for help, say, Judge, these guys aren't doing what they're supposed to do. The court doesn't really appreciate that in most instances. However, there are some courts, there are some judges that turn around and say, you know what? If you have a dispute that you cannot resolve with your adversary, go ahead and make a formal written motion to the court. And in due time, I will consider it. Now, what does that mean? That means that I would have to prepare formal written papers to the court asking the court to take action, to do something, meaning to punish or fine these people, the defendant, the doctor's attorney, and the doctor for failing to do what they were supposed to do. Once I go ahead and file those papers, now the defense has an opportunity to respond. Now they will go ahead and reply to my papers making this request, and now we will file these papers with the court. The problem arises that the court will not hear or listen to or review these papers for a number of months. So remember, we now have a significant delay in which we are trying to resolve and trying to get this deposition scheduled. 6 months have gone by. If I were to go ahead and make this formal written motion to the court, now it would be a number of additional months before the court would even consider and review our papers. And then, once they go ahead and consider our papers, oftentimes the judge will not make an instant ruling. Instead, they will have time to review it and review the case law to see if there is legal support for whatever position they decide to take. So it could be a month later, it could be 2 months after they review our papers before they reach a decision. So if we were to go that route, now it could be many months before we get an actual answer as to whether the defense is now being forced and compelled to produce their doctor for deposition, which is what they should have done 6 months earlier. The reality here is that this is going to delay matters even further, even though I know that I am right and the defense is wrong. So my goal initially is, hey, pick up the phone and call my adversary. Say, look, what's the problem here? We need to get the doctor scheduled. Otherwise, I'm going to ask the court to sanction you and compel your doctor to appear for a court-ordered deposition. And failure to do that will result in various fines and sanctions. And in most instances, the defense attorney will agree. However, in this particular case, the defense attorney said something remarkable to me. He said, listen, do me a favor. Hold off on getting this deposition. Hold off on applying to the court for this motion to compel. I said, why? He said, because we're trying to settle this case. I have to talk to the doctor. I need his consent to settle. And I've already spoken to the insurance company, the doctor's insurance company. They want to settle this case. So if you don't mind, hold off for a little bit further so that we can go ahead and start negotiating. So that's what happened in this particular case. Does it happen often? No, that's not what happens often. Instead, after my client is questioned, now we set up a schedule for when the next doctor is going to be deposed, and the next one, and we proceed along with discovery. So why do I share this quick information with you? I share it with you just to open your eyes, to help you understand how these types of cases work in New York. You know, I recognize you're watching this video because you want to see the beautiful beach here. No, I know you're not watching it for the beach. I know you're watching it to learn about how these types of cases work. I recognize you likely have questions or concerns about your matter. Well, if you have not yet started a lawsuit and are still thinking about doing so, but still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.